no family members, no tribe to be named, nothing, but you have this belief.
My grandma
that,
said that
you were Indian.
That we were Indian, but she died.
She's
Where did your grandmother live? Where did your grandmother live?
Yeah.
Of course not.
Yeah. Where did your Kathy's right. Where did your grandmother live?
In LA.
Okay. If you really can't get anywhere with any more information, then yes, I do check the box that says I may have Indian ancestry and provide no further information at that point. The department is supposed to notice the Secretary of Interior and the Bureau of Indian Affairs. That's all that's required. That's generally really easy to do for them, and they respond, in my experience, the fastest. So that probably won't delay your, and most of the times if they're only noticing the BIA and the SOI, it's going to come back that they say no. But yeah, I just would probe as much as I could, and if you do have that client, you still got to say I may, but move on. Anybody else? Yeah.
Hey, so we talked about this earlier, but my biggest concern, I think, is the no time waiver issue.
Right.
Because I've had a lot of times where I've had a no time waiver adjudication and want to get the kids home to my client. ICWA notices they're not back, and my client is saying, I just said I might have Indian ancestry. Can I just waive it? I don't have it. I don't want anything to do with it. I don't believe that it'll be my duty then to stand up for the tribe and say, no, we have to advocate for further notice. In this case, I would actually probably say, well, I'm going to go with the ICWA case and argue that we could waive notice. Only because at that point, because I get like that, I agree that case to me anyways is stupid, and we shouldn't be able to waive a tribe's right to notice. We shouldn't be able to. But there's certain circumstances that I would think that we could use that in order to get a kid home faster to our client.
So I've thought about this a lot, and you're not the only person who's talked to me about this, and I've gave a couple answers, and I have done some research, and spent way too many nights thinking about the Indian Child Welfare Act and how this would impact our no time waiver trials, and trying to reconcile it with other sections of Welfare and Institutions Code. Number one, there is a specific code section 224.2E which says that any person is subject to court sanctions if you knowingly and willfully falsify or conceal any material facts as to ICWA or counsel a party to do so. So certainly do not tell your clients at the beginning of a case, if you really want this to go quickly but you think you might have ICWA, don't say anything. You are setting yourself up for some major trouble right there. Now, with regards to no time waiver trials, I think that courts, so WIC 334, which says that you have your no time waiver, the trial must be within 15 days if detained, 30 days if non-detained, is used oftentimes in conjunction with a lot of other code sections. WIC 352. Just because you ask for a no time waiver trial doesn't mean that the court cannot permit a continuance under WIC 352. They look at it and it allows a continuance if it's in the best interest of the child. Or if it's not going to be contrary to the best interest of the child, considering a variety of factors, which I'm sure all of you are very well aware of. So there are sections that sort of do allow for continuances despite a parent's right or desire to have a no time waiver trial. And I believe that a no time waiver trial still requires notice to all necessary parties. You have to notice the parents. You can't go forward if parents have not been noticed for a no time waiver trial where maybe the department failed to notice daddy's in the petition and you're trying to force it to go forward. Well, it sucks, but notice has to be proper to all parties, and the tribe is a potential party in a case. And so although ICWA kind of seems to suggest that we have a right to waive, my reading is more so that we have the consequence of waiving our right on appeal as opposed to a right to waive at the trial court level. Basically, what you can end up doing is hurting your client at the appellate court level as opposed to helping them at the trial court level. And additionally, both the federal code, the Indian Child Welfare Act, and California law, as it's codified the Indian Child Welfare Act, make this duty imperative on the courts themselves. So the court has its own duty to make sure that notice is proper. It's, it stands alone from our duty to inform the court. It stands alone from the social worker's duty. It stands alone even from the child's attorney's duty, because this is something that we have a party who may be out there who has no idea that they are a party to this case unless somebody gives them the proper notice. Is that kind of
I'm not sure if that would be our duty to ask for a continuance because it was not followed, because I don't think that it would be your duty to ask for a continuance. However, it is probably a good idea to, maybe you don't want to do it on the record, maybe you want to off the record say, look, it doesn't appear that notice is proper in this case. You can object to a continuance. You can preserve your right by objecting to the continuance. Nonetheless, the court would be wrong to go forward on a case like that and could invalidate all future proceedings, including maybe you successfully winning your case, or perhaps you partially winning and then getting to a point where you're at dispo and now you want the benefits of the Indian Child Welfare Act, but you're too late for that. Yes?
I have a twofold question. One, what do you suggest then that the attorneys do? Because many times you'll see it dispo, not so much in Department 421, but in the other courts that are doing the ICWA cases, or not, where there is a question as to ICWA notice, where you'll see it dispo, the court will go forward and make dispo findings and then put over the ICWA notice to
progress
court or the next date. And I know we need to embed the record at some point. So one, my first question is, what do you suggest what is the script that our attorney should be saying at that point? And two, it's similar to what Christina is. If you say, if we have, let's say, the non-custodial parent, and there really isn't a basis for any detriment, and we're trying to get that kid to the non-custodial parent by dispo as soon as possible, and you have this competing issue of ICWA, maybe the mother's side, I don't know. How can we make arguments to have the child at least released to the parent? And
Absolutely.
Then put the ICWA issues over, not for anything other than dispo, but at least say there's no detriment, released to the non-custodial, and then we'll just continue the dispo for ICWA?
Well, I would say under it, just as you can, permitting, allowing that, if your court allows you to do it, make release arguments up and to the dispo portion. I mean, it would really depend on the court, but I think that you could always make that argument, and especially if you're able in many courts to get minors counsel on your side, then you might be in a position where the court would say, we can't go forward just yet on the disposition per se, but we have this information here. I don't see any risk to this child. I'm going to release to the father at this time. I think you would make that argument in the same way that you could on any other case. Say you're having a Hague notice issue, or something else that's putting your case over and over for notice issues. As to the first question, the script per se that I would have counsel use is the notice timeline slide number 2, which basically says that, under California Rules of Court 5.482D 2 and 3, that although the court is not required to delay the proceedings for a response, the court must apply all substantive provisions of the ICWA, and that includes as codified in California statute, until it's determined that the child is not an Indian child. And the court cannot make that determination until either receiving all the responses back that say, no, this child is not eligible for membership and is not an Indian child as defined by our membership terms, or until 60 days after receipt of all of these notices and nobody's responded. So basically, I mean, I don't know, maybe I can't think of any court, and I haven't come up against any court who then would say, all right, well, let's just go forward under ICWA standards. Let's get a qualified expert witness in here and go forward with that. Most of them at that point will say, okay, I'll just put it over the 60 days or the 20 days or whatever it is at that point that you're waiting for the green cards back. As for the issue that you guys are going to quarrel with your clients for no time waiver or for the non-offending previously non-custodial parent, I don't really have a good answer for that. It's just one of those unfortunate things where in maybe those rare circumstances it does operate perhaps in our minds a little bit contrary to the interests of the child. However, what the ICWA says is it's always in the child's best interest to maintain those connections to their tribe and to be able to have the benefits of that connection. So it is what it is. It's the law. There's no way around it. Yes?
Doesn't the impoundments court, when we have issues like with the dispo, and we have a parent who we think that she'll release to, we always just get a tentative from her. And she always says that if the tentative is to release to that parent, she goes forward with disposition and does the ICWA later, because there's no removal for the parents. You don't need a letter from a qualified expert, or that heightened burden doesn't really apply because she's going to release it to the parent. Anyway.
That is true. ICWA only applies where there's a foster care placement at issue. If the court is going to absolutely release that dispo, then I guess you could go forward. Also, if the department changes their recommendation and their recommendation is no longer suitable placement, it's home of parents, again, then the considerations of the ICWA are not at issue. So, however, that doesn't change the issues of notice timelines for starting out with the adjudication. That just makes it to where, for disposition purposes, the higher standard would not apply. Yes?
I just think it's probably important to point out that it doesn't have to be released to the ICWA parent.
Absolutely not.
That it's released to any parent, so everybody's a parent. So even if it's the parent that doesn't have ICWA ties, it's still released.
And in fact, let me just really quickly, that goes to the highest standard at disposition that we deal with if a case is ICWA, is that the court may order an involuntary foster care placement. Well, that doesn't apply if the court's not ordering an involuntary foster care placement, right? So we're immediately out of the issues of timelines and disposition if the court is deciding to order home of parent, either parent, as Amy pointed out. But the court may order this only if it determines by clear and convincing evidence that includes the testimony of a qualified Indian expert or qualified expert witness, that the continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. The most, I think, important part of this for me has been the requirement of a qualified expert witness. And I learned this, I guess, the good way one time in deciding to cross-examine a qualified expert witness. I had, when I first was hired here, I was put in the ICWA courtroom, which was 413 at the time. And I had, at this point, shamedly done a number of ICWA cases, just taking the ICWA expert's letter at face value. It said in there that they had this many years of experience, and that they reviewed the court reports, and that this is what they determined to be their opinion, and that they provided this opinion to the court. Well, as if anyone decides to come to part 2 of my training, I will talk a lot more detail, and I was possibly going to provide an interactive testimony experience for a qualified expert witness of what would be a good example of that and what would not, because as you will come to find, there are a lot of really bad expert witnesses, whether they be Indian experts or other experts. But certainly the most helpful part of the standard is the requirement for live testimony by someone who is familiar with the practices of the tribe at issue or has familiarized themselves with the family to make this statement, and who is someone who is separate and apart from the county, although oftentimes hired by the county. Now, I did want to, I know there's only like 10 minutes left, briefly touch on some limited issues that I could finish up today, and then the more detailed examination of active efforts, which is incredibly helpful but incredibly convoluted. There's a lot that goes into active efforts. Yes?
Do you know if we have a list of potential experts that we could hire ourselves to provide testimony?
There is a list on the California Courts website that includes about 6 or 7 experts, 4 of which I have experience with, and they're terrible. And my advice to you would be to contact the tribe directly. And you all have the ability to do that. My advice to you in any of these cases would be as early and as often to try and get in contact with the tribe and say, look, this is the situation we're in, especially if the department starts going forward and the experts on the California court website, a number of them are social workers or retired social workers from, I think 2 of them are from San Diego County. Another one is, I've had them use Crespo in a case one time. These are the kind of experts that the county will be looking into. The best expert that you're going to find who is most likely to be on your client's side, and if they're not, then you're in trouble, is most often their tribe, someone who's provided by their tribe. And I have had a case where the department put forth Crespo. I was able to put forth an expert from the tribe of the mother, and it became a battle of the experts, which was won by our expert because Crespo did not really have any familiarity with Indian child-rearing practices or the tribal culture and traditions. And so that would be my advice to you as far as experts go. Yeah.
If this one keeps getting put over for lack of the expert letter, which is the department's requirement to provide, what's the parent's remedy? Do we have to continue DISPO?
Well, I'll just jump to this part because it's not that detailed, but that was going to be part of part 2. One of the things is a letter is actually only sufficient for the terms of the disposition and actually TPR standard if all parties stipulate that they will accept a letter as opposed to live testimony. I would say, you know what, we don't have a letter, but the person has to be available. It's like the department saying that the social worker is not available for testimony on a juris dispo report. At some point, the court can, I guess, maybe set an OSC or order the person in. You could subpoena that person. They have to give you the information. You could subpoena that person in. I mean, they have to be available for live testimony, and you only accept the letter if you all choose to by stipulated testimony. I mean, by stipulation in writing. So, I mean, you could try and, with permission of, contact the person or just issue a subpoena for them outright. And if they are not showing up and they have not provided a letter, well, then it's bench warrant time. Any other questions about these scattered issues?
We're talking about qualified expert witness, and I see them opining apparently on the likely serious emotional or physical damage to a child. These folks therefore have some very special psychological training and insights that allow them to opine on that?
That's why they need to be qualified. So certainly that is part of the qualification that you would engage in trying to indicate to the court whether you believe this is actually a qualified expert witness. I mean, there are two ways the qualified expert witness requirement can go in the case.